Hey, what's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. I don't know if my camera is working there, but it doesn't matter. The information is more important. In today's video, we're going to talk about how you can beat LVNV funding, LLC, LVNV funding, LLC, and they are also their parent company is Capital, Resurgent Capital. They Resurgent buys the debt. LVNB funding is the organization who goes after the debt. So first, what I want to do is I want to talk about some of the common uh, uh, laws that debt collectors break. LVNB funding. These are common with them. They're common with other debt collectors. They may or may not violate them, but I just want to go over this, and then we're going to talk about how to beat them. A lot of people talk about some of the surface stuff, which is very important because they do this in a roundabout way, and you can win a $1,000 violate per violation if you can prove it. And there are certain ways uh, that you can record the information to be able to prove your case and take them to court and get a $1,000 payment on the violation. And they usually settle those out of court. They don't like going to court on that because they could lose their license. So here are some of the common ways that debt collectors break the law. According to the Fair Debt Collection Practices Act, it protects consumers from harassment and privacy violations uh, by bill collectors or debt collectors. And the first one is disclosing your debt to anyone other than you. They cannot do this by calling people, even if they have your friend as a reference on your application. This is how they end up calling people. They have your friend or your relative's information on the application. They can call to try to find out if you have a different number or something. They don't have to give that to them, but they could just say that they're trying to contact you. But here's the problem: they can't say who they're calling from. They can't say who they're calling from, debt collector so and so company or LVNV funding, to collect the debt. That would be a disclosure to someone without your permission. So it's a thin line on how they're able to try to do it. Some of them try to do it because they don't think that you know the laws on being able to get them, to be able to sue them for them violating it. So another way that they can violate is by sending your information on a postcard. They might try to do this to save money. They don't want to pay the fee for first class mail, which we could see that first class mail is going to be $1 pretty soon. And just think, if they wanted to send out to 1,000 people to try to collect on the debt, that's going to be 1,000 extra dollars that they did not normally have to spend. Now you might be saying, well, they're going to send it with bulk mail. They're going to send it through a company. Well, that would be a violation of disclosing your debt to anyone that without your permission. And LVNB funding has got in trouble for doing that, where they were using these bulk mail centers, mass producing documents, and that's disclosing your information to an unauthorized third party. So watch out for your mail. If you had a mail that comes in and it shows that it looks like it's been done by a third party, you can question LVNV funding to see if they submitted your information by a third party. Now, the next thing is falsely threatening to sue you. This is a gray area. The Fair Debt Collection Practices Act does not uh, give like a timeline, but the timeline that I always go by is 30 days. If they threaten to sue you and they have not sued you within 30 days, you can write them a letter stating that they're in violation of the Fair Debt Collection Practices Act by threatening to sue and they did not take action. Now they might try to take action. That's why a lot of people don't like this the way that it's stated in the Fair Debt Collection Practices Act, because if you say, well, send them a letter, you threaten to sue us, and then they're like, okay, well, we're just going to go ahead and sue you. And the way, even though they would be in violation, you would still have to go to court to prove that they're in violation, because the next step that they're going to obviously do is to sue you. And then you're going to have to respond with them saying that they only sued you because you threatened uh, to sue them because of the violation, or because you notified them that they were in violation. The next thing is lying to you to try to collect. Saying that there's with someone, another company, or that someone referred to you or whatever. They could just come up with a lie to be able to try to collect the debt from you. Or they say that, hey, we're the police. They can't do that. They can't say that there's someone that they're not. Also, if the debt collector representative calls you and they're not an attorney, and they say that they're an attorney, that's against the Fair Debt Collection Practices Act, because they're lying to try to collect from you on the debt. And again, lying to try to collect is falsely threatening to sue you. Now, calling you multiple times per day. They're not supposed to call you between a certain period of time, which is, I believe it's, in most cases, they can't call after 7 p.m. and they can't call before 8 a.m. In some areas, it might be 9 a.m. And then call them multiple times. You would have to record this, but if they call you multiple times per day, they cannot do that. Some states allow them to reach out one time per day or one time per week. Misleading you to try to collect the debt by saying that, hey, we can get this maybe they might say, hey, we can get this removed off of your debt, off of your credit reports, if you go ahead and pay this debt. But they're really lying to you. They're just trying to mislead you to try to get you to pay them something. And then again, calling family or friends, calling you at work, because that could put you in jeopardy. And then changing your payment plan after you have an agreement. So after you have an agreement, and this just recently happened to someone that came to us, they had an agreement, and when they got the agreement, they had actually made the first payment, but when they got the agreement was totally different than what they had agreed to when the judge allowed them to go into court, into a side room to discuss how they would make a payment arrangement. So now let's talk about how to beat debt collectors, and specifically how to beat LVNV funding. So these are the steps to beat them. So the first thing that you need to pay attention to, we're going to go from 1 to 10 here, is the 30-day dunning letter. Did they send this to you, or did they email it to you? Because now with the new laws, they can email it. They can email a request to you. And a lot of debt collectors are doing this to try to save money. So they can reach out on social media. They can reach out by email. But did they send the 30-day dunning letter? Because it's very important, because the 30-day dunning letter gives you the opportunity to dispute the debt. So in that letter, did it have these three things in there? Number one, identify them. Number two, identify the original creditor. And number three, give you the opportunity to dispute any or part of the debt. In all of the debt or part of the debt. It has to have a specific line giving you that opportunity, and you have 30 days. Now, when you respond to them, they only have 5 days to get you all the information that you dispute. If they break that law, they are in violation of responding to you when they should have responded to you on your dispute with the debt. And then you would just need to package that up and submit it to them again, saying you're in violation of the 5-day rule. That's what you would have to do. Now, even if they do that, they could still try to pursue. They could still try to pursue you, because to make all of this stuff happen, you're going to have to take them to court. That's the thing. To make all of this stuff happen, they're going to have to take you to court. The next thing is we want to check the statute of limitations on the debt. So again, this is before we're really contacting them. You're gathering your information. So if you check the statute of limitations, don't worry. I'm going to give you a letter if they did not, if it is past statute of limitation, I'm going to give you a letter that you can use for that. So don't worry about that. But if it's past the statute of limitations, you don't have to do a debt validation. You just have to notify them that the debt is past legal statute of limitation. I have a letter right here in front of me from a new client who got a debt request, demand letter, and the debt was past the legal statute of limitations for them to be able to collect. The next one is submit if it is not past the legal statute of limitations to collect, you need to submit a cease and desist letter. Now, the cease and desist letter, a lot of people are getting this confused with a cease and desist collections letter. The one that I give you is cease and desist collections activities letter. This is not a cease and desist letter to stop them from contacting you over the debt. Because what we want to do with the cease and desist collection activities letter, and I'm going to give it to you, but the cease and desist collection activities letter is to question them on every aspect of the debt that they've purchased from the original creditor. It has a list of questions that you want to ask them, and within there is a debt validation letter, a debt validation question inside of that cease and desist collection activities letter. Now, the next one here, number 4, if they don't respond, you need to wait. Depending on your situation, if you're trying to buy a house and you need them to respond, then you need to call them and ask them why they didn't respond. But if they don't respond to you, then you can ask them, if you can wait it out, because they may be, reviewing it to just see what they're going to do. Also, when you make that dispute, it does go into a 90-day waiting period. So you may have to rescind the cease and desist if you want them to talk to you about the debt. Now, if they do respond, which they normally do with some documents from the original creditor, you need to review their complete response because they may have some other information. And then you need to resubmit a debt validation because they never give you a complete debt validation. They'll just give you what they got from the original creditor. The next thing is if they respond with all the original creditor documents, you need to determine what is going to be your next move, which is right here, your next move. Do you want to settle or do you want to fight? If you want to fight, then you would just simply tell them that, you would go, tell them that this is not a complete record of the debt that you had with the original creditor. If it's a repossession or something like that, it may be a little bit harder for you to state that because it's going to just be one item, which is the one loan on the car. Which what you will want to do is to make sure that there was no issues with the finance company that financed the vehicle. You want to make sure that there's nothing wrong with the contract. You want to make sure that you got the complete auction statement. You just want to review everything around that auto loan. If it's with a credit card company, you're going to want to request all of your charges, all of your payments, all of your rewards, balances, everything from that credit card. The next thing that you're going to want to request from either one is if there was a 1099-C filed, and I suggest that you call the IRS to see if a 1099-C was filed. The next step, if they take you to court, what to do? You utilize the information that you submitted from your debt validation request, from your cease and desist request. You're going to package all of that up, and you're going to put that information in your response to the court summons. If you win in court, what to do? You use that information to get it off your credit reports if it's on there. And other than that, you just take your victory and you leave court smiling. If you lose in court, what you need to do is you can ask for time to either resubmit to have them reopen it, but that's going to be very hard because you're going to have to come up with new evidence. The next thing is that you can move to settle the account with the debt collector if they happen to win. So now let's get into the letters. If I'm going to make this available to you. There's a link below here, and you can grab my 3-pack of letters: cease and desist collection activities letter, statute of limitations letter, and a debt validation letter. Instructions are inside of there. I do want you to grab those if you have debt collectors coming after you. You can stop them early in the game from coming after you for debt. I do ask for a donation on those. These three letters, utilizing one of the three letters, could save you time, money, and a lot of frustration. These letters do work to stop debt collectors from coming after you. If you have debt collectors that are already suing you in court, then you need to consider the link that I have below to stop debt collector lawsuits, to fight back against debt collector lawsuits, to get your defense, uh, affirmative defense put together for you. There's a link below this video for that if you need it. I show you how to do it, or you can have us do it for you. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video. Watch the video, What Makes Us Different, so you can see my 8-point validation process and my two-phase settlement process. If you need your credit reports and scores, and you need that information because that could be very important to prove statute of limitations, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports, and all three scores. Thank you for your time. Please subscribe to the channel if you haven't done that. Post your questions and comments. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.